Hey guys, let's get into it today. I promised I would go over some new court documents in the Bryan C Kohberger case, and let's go over them. In the District Court of the Second Judicial District of the State of Idaho, in and for the County of Lake, please take notice that the undersigned, pursuant of Rule 16 of the Idaho Criminal Rules, the 4th, 5th, 6th, 8th, and 14th Amendments to the Constitution of the United States, and Article 1 and 1 and 2 and 13 and 17 of the Constitution of the State of Idaho, request discovery and inspection of all materials discoverable by defendant per ICR 16B1-8 and defendant's 11 supplemental requests for discovery. Now, what's going on here, guys? They still haven't gave him the discovery. The aforementioned constitutional provisions, including but not limited to the following information: evidence and materials obtained in Exhibit 1, dated this 9th day of January 2024. I hereby certify that a true and correct copy of the foregoing was personally served as indicated below on the 9th day of January 2024. Latah County Prosecuting Attorney via email. Why haven't they not still given over the discovery evidence? That's what I'd like to know. And this new one, the defense is wanting the records unsealed. And they're wanting the IGG as well. On October 25th, 2023, the court issued an order addressing IGG DNA, an order for in-camera review that addressed the state's motion to prevent the disclosure of the investigative genetic genealogy, IGG information to the defense, and the defense motion to compel discovery of all information pertaining to the IGG investigation. On November 30th, 2023, the state submitted to the court in camera all IGG information pertaining to the state's investigation from both FBI and a private laboratory. The court has now completed its review of the information provided by the state and orders the state to discover to the defense a portion of the IGG information. The specific material to be provided is set forth in a sealed order to protect the privacy of the IGG information, including individuals on the family tree. What's up with sealing all the freaking records? It's like, guys, they don't want anyone to see it. This is really getting weird, guys. Motion to unseal defendant's motion to reconsider. Let's get into that one, guys. Comes now Bryan C Kohberger by and through his attorney N.C. Taylor, public defendant, and hereby moves the court to unseal the defendant's motion to reconsider orders denying motion to dismiss indictment, and in the alternative for permission to appeal the interlocutory orders and a stay of proceedings filed with the court on 12/21/23 to appeal from and the state's objection to this motion that was filed with court on 1/5/2024. This motion is made on the grounds that the pleadings and hearing thereon do not need to be sealed. Previous motions related to the grand jury proceedings were properly sealed pursuant to ICAR 32, Idaho Criminal Rule 6, and the court's order relating to the grand jury proceedings. The pending proceedings brought by motion and supported by pleadings do not meet the language of the rule. The issues for the court to decide a procedural and legal and do not delve into the areas covered by rule and order. Mr. Kohberger sought sealing of his filings solely based on email communications with the Latah County Prosecutor Office stating that they wanted the filing sealed. Now, why would they want the filing sealed, guys? The deadline for Mr. Kohberger's motion was imminent. Thus, in an abundance of caution, the defense filed a motion to seal. Counsel for Mr. Kohberger informed the Latah County Prosecutor's Office a motion to unseal was forthcoming. Mr. Kohberger moves the court to unseal proceedings and filings on the basis that these filings and proceedings are not covered with the ICAR 32. Mr. Kohberger acknowledges the right of the public to be fully informed on the issues. Mr. Kohberger has a right for the rule to apply as it is written rather than disadvantage him with items remaining sealed that are not within the scope of the ICAR 12. And guys, I totally agree with him. This is ridiculous. Why is the prosecution sealing everything? I mean, what's next? Every time he sneezes, are they going to seal that? Oh, he sneezed in jail. We need to seal that. This is absolutely insane, y'all. It's insane what they're doing to this poor guy. It really is. Temporary order sealing objection to defendant's motion. Why would you want to seal that? Motion to temporary seal objection. Order sealing defendant's motion for interlocutory. Motion to seal defendant's motion for interlocutory. Motion for scheduling order. His attorney, guys, has sent 11 requests for discovery. 11. And the prosecution has not even, I would see, okay, after getting one summons for the discovery evidence, okay, if they didn't do it after one, maybe two. Now, if they did it after two, that would be cool. But 11 requests, and they still not have turned over the discovery evidence after 11 requests. And that was on the 9th of this month, guys. Defendant's 11th supplemental request for discovery. And then what they do after that, after the discovery, they only gave him a small portion of the IgG, and they sealed the rest. What is going on with these fucking people? And poor Kohberger, he's sitting in the midst of sharks. He really is. Yeah, I honestly feel sorry for the dude. I really do. I feel sorry for him. Sitting in jail for almost 2 years, your stuff still hasn't went to trial, and now you have the prosecution not wanting to turn over the IgG information, and when they do, and if they do, they only want to do a portion of it. It just really sucks. Okay, let's get into a little Bryan Kohberger courtroom action.
Are you struggling to become a successful trader? What if I told you I make between $1,000 to $15,000 a day?
Well, good afternoon and welcome to the Law and Crime Network. I'm Linda Kenny Bodden. Our trial coverage today takes us to Idaho, where the man accused of fatally stabbing four University of Idaho students last year is set to appear in court. Bryan Kohberger is expected to be arraigned today on 4 counts of first-degree murder and 1 count of felony burglary for the brutal slayings of Kaylee Gonsalves, Madison Mogen, Xana Kernodle, and Ethan Chapin. Kohberger has been in police custody, as you know, since late December when he was arrested at his parents' home in Pennsylvania following a week-long search for the suspect. Kohberger is expected to enter his plea today as part of the proceedings. And of course, we will bring that to you on air and online as soon as we have it. And stay with us because later in our show, we will have a live question and answer hosted by Anjanette Levy, who is in Moscow, Idaho, as our boots on the ground. But before we get to that, just last week, the 4 University of Idaho students were remembered for their strength and inspiration as they were awarded posthumous degrees. Let's take a listen.
The University of Idaho awards posthumous degrees to students who completed sufficient coursework prior to their untimely death. This is a moment for us to acknowledge the contributions they've made and celebrate their academic achievement with their families here today. This spring, we will award 5 posthumous certificates and degrees. During a private ceremony on Monday, we awarded a certificate in marketing to the family of Xana Alexia Kernodle. A certificate in recreation, sport, and tourism management will be delivered to the family of Ethan James Chapin in the coming weeks. Later today in our afternoon commencement ceremony, we will award 2 posthumous bachelor's degrees. A bachelor's degree in general studies to the family of Kaylee Jade Gonsalves, and a Bachelor of Science degree in Sociology and Criminology to Lupita Colis Ruiz. Now, we will present a Bachelor of Science in Business degree to the family of Madison May Mogen.
Wow, I am sure the families of these victims had to be crying as they listened to what could have been and what they could have watched with their children going on stage to get certificates and degrees. But with me to discuss all this and what is going to happen in court, you know him well, Bob Mata, criminal defense attorney, host of the Defense Diaries podcast, and of course, Ron Zambrano, trial attorney. So Ron, let me start with you first. I have read a lot online, people saying, well, will Bryan Kohberger plead guilty today or is he going to plead innocent? Tell our viewers what happens at the first arraignment after a grand jury indictment with a defendant.
Typically the defense in a very nervous position, but by now he's already got his plea already set up. So I know a lot of people think he's going to plead, not a lot of people, but some people are debating. I think he's going to plead not guilty. A lot of this evidence is circumstantial, and I think he'll take a shot because, but you know, with all the phone evidence, all the phone calls with boyfriends and where his phone was, I think he's got a long shot. But I think because it's mostly circumstantial, I think he'll take a shot and fight it and plead not guilty.
And of course, Bob Mata, let's talk about this. When he gets to plead not guilty, his attorney could actually enter it for him, or he can speak. Now, there is a famous case that we all know about, and some people have read about, where a defendant said, I'm 100% not guilty, I'm 100% innocent. Do you expect that Bryan Kohberger is going to actually enter the plea himself? And will he make a statement, or will this be just a mundane arraignment as we know in criminal law?
I think it as much in my mind as I think that the defendant is going to make the pronouncement himself. In my mind, he's doing exactly what you said, but in reality, I think that Ann Taylor will probably enter his pleas for him. And I'm going to go with 99.999%. He's going not guilty on all counts.
Yeah, I can see that you're a betting person here, leaving a little bit of doubt. So, Ronald, let me go back to you. This is actually a very serious occasion because they're going to have a number of things happening in court today. They'll be discussing the gag order. They'll be discussing discovery. And there have been some, shall we say, hiccups, says the defense, on behalf of the state giving them discovery. But that's also normal at this stage. Give us the posturing that goes on before an indictment and right after an indictment.
So a lot of what happens before the indictment is kind of you're trying to just fulfill your duty so that later on there's no arguments that something wasn't copacetic, that there's some type of due process issue. So and anything that doesn't go 100% cleanly, there's going to be some wrinkles, and everybody kind of understands that. After the indictment, things kind of get more formal, and you kind of have to have your ducks in a row and T's crossed. But by then, the defense attorneys and prosecution have kind of been communicating already, and they should have a report in order to avoid anything that can become a real issue later.
And Bob, before I play some tape that we have, I have one more question to you. This likely is a death penalty case. There was another death penalty counsel that was added last week. She may have do some real estate, but she's also death penalty certified in the state of Idaho. What do you think is going through the prosecution at this point, and do you think they're going to mention that in the defense at this point, at this arraignment?
This arraignment, no. I mean, it's possible, though. I think that the prosecution is absolutely going to be seeking the death penalty in this matter. In terms of the timing of them reinstituting the death by firing squad in Idaho, the timing seems you have two major cases that were happening. You had Vallow, and actually three, Daybell, but Daybell and Vallow were originally supposed to be one trial. It got, those got severed, but we've got three major cases, all death penalty eligible. And it was very, very recent, I think in the last 6 months, that Idaho brought back death by firing squad. And again, just so people understand, they have to be unable to obtain the cocktail for lethal injection or to go to firing squad. It's not the default. So, and I wanted to throw that in there because I think they're definitely going to go for the death penalty. And I think that this might be the first guy that I've ever heard of in my lifetime that is killed via firing squad.
Very, very interesting. Now, everyone wants to see Bryan Kohberger, although when I tweeted his picture in my social media, I was like, oh, I'm going to be watching that for a long time. But the poor victims, if he is guilty, they're the last person, or he is the last person they saw. So we owe it to them. But let's watch him before he's actually arrested, when he's in the car with his father, shall I say, escaping Idaho, going to Pennsylvania. Well, that's something that will be decided in the future. But let's listen and let's watch.
Hello. How you doing? How y'all doing today? Good. Take a look at your driver's license real quick if I could. See, he's right up on that van, man. He's right up on the back end of that van. Old driver. For tailgating. Is this your car? Okay, cool. Where are you headed?
Well, we come from WSU, and we're scanning.
What's WSU?
University, basically. That is fought to Europe.
So okay, I'm having a hard time hearing you because of the traffic. So you're coming from Washington State University?
Yeah.
Do you guys think it's kind of odd that he got pulled over twice? And do you think it was a so they can get touch DNA off of him? Let me know down in the comments.
And you're going where? Oh, okay.
Yeah. We're slightly much right for hours.
Hours, days.
To drive. Well, almost.
Okay. So what did you say about some SWAT team thing?
Yeah, there was a mass shooting here.
Where? Interesting.
Well, it's horrifying. It's going to the university.
Mm-hmm. So y'all work at the university there? Or?
Actually, we were there.
Oh. Okay. Okay. Yeah, I hadn't heard about that incident just yesterday, or?
This happened yesterday. About an hour and a half ago, still wrapping up. I'm not sure the sushi is, but they did shoot somebody.
Was there?
And then you don't know about that actually. They were there.
Interesting. Wow. Okay. So do me a favor and don't follow too close, okay? All right. Thank you. Appreciate you.
State police got your license registration. I stopped you when you were driving by me there. You were a little close back at semi. In the back of this trailer.
Big news, folks, because in the next 90 seconds, I'm going to show you how to get a one-way ticket to Millionaires.
Before I ask questions of my panel, I do want to keep our viewers advised that Mr. Kohberger is in court and the judge is on the bench. As soon as we get that footage that the judge will allow us to have, we will bring that to you. But let me go to you first, Bob Mata. Okay, when I first saw this, I said, there's no way people getting pulled over for tailgating, especially twice within a very short period of time. I was convinced the first officer was actually getting the DNA off the license. And since they know the first officer's DNA, that they could separate out the mixtures. But if that is not Brady material proving innocence, the prosecution seems to take a position that nothing gets given to the defense unless it proves innocence. Your thoughts?
Well, obviously, as a criminal defense attorney, that's absurd. We have a right to everything. Anything that they intend on using at trial, obviously, we have an absolute right to have. And frankly, I was having a rather long discussion about the genealogical DNA that they're refusing to turn over, from the search at the parents' home in Pennsylvania. And I'm trying to understand what the state is trying to hide. You know what I'm saying? It's because at this point, it's rather moot that they're asking for the genealogical DNA, unless of course the DNA was all consumed during that first, the first making of the profile in order to get the genealogical match with the father in the sheath, right? So if they consumed all the DNA at that point, that's a major issue. And that means that's the only profile that's been made in terms of the DNA.
And Bob, we're gonna talk later in the show about the genealogical DNA, because that's where this all comes from, is the refusal to turn it over.
Now, guys, why do you think they want the secret grand jury indictment? Do you think it was because they knew that they didn't have enough evidence to indict him without the grand jury? Because it just seems kind of funny, guys, that he's been sitting in jail for the last couple of years almost, it seems. This coming November will be 2 years. And then the Pamela grand jury don't let the defense team know. It just seems kind of odd and kind of fishy, like a setup. That's just how it feels to me. Is like he's being set up. Why didn't the prosecution turn over the other three male DNAs to the defense, and the judge telling the defense the other three unknown male DNAs don't exist. Tell me what you guys think down in the comments. Now, I'm still going to be covering this case. I'm going to be uploading a couple more videos later on today. And please hit that like, subscribe, and share button. And if you want members-only perks, hit that join button. You guys have a good day. Peace out.